Welcome to Legal Talk, a program brought to you by the law firm of O'Donnell, Weiss & Mattei, PC, with full-time offices in Pottstown and Phoenixville. We are a full-service law firm, and today we are bringing you a fascinating program about grandparents raising grandchildren. And with us today are two members of our firm, Rebecca Hobbs, who is a certified elder law attorney, and Melissa Iacobucci, who is a member of our firm who concentrates her practice in family law, custody support, those issues. So this is an interesting issue. But why is it such an exciting issue, Becky?
Yeah, I think the grandparents raising grandchildren is a really important issue. Just as we look at statistics, we can see why it's become so important, specifically to Pennsylvania and the United States. In 2010, and there wasn't a recent data, but this is as recent as I could find. In 2010, there was a census that revealed in Pennsylvania alone, there are 239,000 children under the age of 18 that live with either a grandparent or another relative. So to give you an idea, that's almost 9% of the total children in Pennsylvania. So that's a big deal, and that really is something that we have found has affected the clients that we service in our area.
Yeah, so Rebecca, stay with this a little bit. These are shocking statistics to me. And why should a grandparent do something to formalize the relationship? Beyond, okay, child is with the grandparent, very nice, but why should the grandparent want to formalize that? And again, that would be as a guardianship or a custody action.
Yeah, well, I think that where you have a grandparent or another relative that is raising a child, there are some roadblocks that can come up that if they don't have that formal legal relationship can really create some issues. And sometimes, they're not going to realize that until that issue presents itself, and then you're kind of in this crisis mode where you're trying to figure out a way to make a decision for a child. One of those roadblocks could be as simple as enrolling the child in school. And, the school district is going to want to first see who has custody of the child, or if you don't have custody, do you have a guardianship order? And I know we're going to delve into those topics specifically, but that's something that will come up for the grandparent, and then they're faced with, well, how do I enroll my child? How do I enroll this child, into school? Fortunately, there are two kind of exceptions where the grandparent doesn't have that formal legal relationship with the grandchild. And one of the situations I actually had to use recently for a client, and it's the McKinney-Vento Act. So it's a federal act that exists, and it's kind of an exception to that general rule of you need to have custody or you need a guardianship to enroll a child. And this act specifically focuses on a child who is considered homeless. So if a child is considered homeless, then they can still enroll in school under this federal act. In the situation that I had this apply, it was a young child where the parent had passed away, and there was no other parent in the child's life. So the primary caregiver had passed away for the child. And in order for the guardian, it was this in-between time where we were going to be seeking guardianship for the child, but we hadn't had time yet to file the petition for guardianship. And so we were able to use this act to be able to enroll the child in school. So that's one exception, and then there is another as well. It's called a Form 1302, and that is another kind of way around enrolling a child in school where you don't have that formal custody or guardianship. And in order for that to apply, there's a couple conditions. So one, you have to show that the person that's caring for the child isn't being compensated for caring for the child. So as long as the person caring for the child, so the grandparent in our situation for purposes today isn't being compensated, they would meet that one requirement. And then the other requirement is you have to sign a notarized statement saying the child lives with you full time, so year round. They're not there just for the purposes of the school year to get into a better school district, for example. You have to certify they live there year round, you're not being compensated, and you sign a notarized statement swearing to those facts, and then the school district will allow you to enroll the child into school.
So that takes care of educational
Right.
issues, although we'll have to go into the specifics of guardianship and custody. But but how about medical?
Right. So it's really the same kind of situation where the golden standard is that the grandparent is going to need to have either custody or have a guardianship order in order to make medical decisions for that minor child. It's kind of the general rule. And then there are, of course, exceptions to that. One exception, obviously, if there's an emergency situation. So if there's an emergency and in the doctor's belief, they must treat the child or that child is at risk for grave, possibly death or a big medical risk, then that doctor is able to still treat the child without having the consent. So again, the golden standard is consent from either the biological parent, the custodial parent, or the individual that has guardianship. But if that's not there and that child needs to be treated, then there is an exception under the Medical Consent Act. There's another kind of exception as well, which this might be, again, when we talked about ways around the education enrollment, this is kind of a way around that temporarily as well. And it's almost like a power of attorney document where the biological parents would sign a power of attorney over to the grandparent, saying that the grandparent can make medical decisions on behalf of the minor.
And if I may interrupt you, that does
Sure.
not need to be a general power of attorney going to the grandparents, but it could be very specific.
Yes.
For education or for health, things of that nature.
Right. Yeah, so the Medical Consent Act specifically allows for this to be a way for a parent, for example, even for myself with two minor children, if me and my husband are traveling, then we'll sign a medical consent for whoever is watching our child to be able to make decisions regarding medical choices for our child in our absence. And it can be for a limited period of time as well. So you can limit the time frame as to when that individual can make medical decisions for your child. But that is a way around having the guardianship or the custody and still be able to make choices for that minor child.
Yeah, many people don't even think about that. They put
Right.
their children with grandparents or aunts, uncles while they go away for a particular trip.
Right.
And they think, fine, there's no problem. Actually, there is a problem, isn't there?
There is.
And,
yeah.
and there is a very simple way around it.
Right. And again, where that would happen in something like a car accident or something devastating happens, then that grandparent in that emergency situation, the doctor's still going to treat the child. But it's more for, let's say the child comes down with an ear infection or something and you need that child to get treated or an antibiotic, that medical consent power of attorney is going to be really, really helpful in that situation.
So we talked about some of the emergency ways
Right.
And a little bit unusual ways of going about getting temporary help for those children, for education and health. But Melissa, in terms of custody issues, how does a grandparent go about approaching custody?
They have to first answer the question as to whether they have standing.
What is standing?
Standing is basically whether you can get your foot inside the courthouse door, whether you can bring an action for custody, whether the court or the judge will even hear your petition. You have the ability to bring it. And for grandparents, it's really hard. There are really narrow circumstances that allow them to even pursue custody.
What are they?
Let's say that perhaps the most popular requirement would be you're in loco parentis of the child. You've been acting like that child's parent. You've been in basically in that parent's shoes for a better part of the child's life.
That's what in loco parentis really
Yes,
means, is it not?
Yes.
Yeah, standing. That it's a little bit of Latin for
Sure.
for us.
Now, if you don't stand in loco parentis, there are still other criteria you could meet. You could the child could be at risk due to abuse, whether that be alcohol or physical or drug abuse or neglect. Or another criteria could be whether that child has lived with you for a period of 12 months, at least 12 months. Okay, and then that child is removed from your house by the parents. You could pursue custody for, I always need to. There's always a third one that always. Yeah.
Well,
The child has been deemed dependent by in the juvenile court.
okay. So that's going after primary custody.
Primary or full, physical.
Yeah. So the physical custody, and actually there's a difference. I know we talk about this in family law very easily, but it's there's physical custody and legal custody.
Yes.
Could you explain just real quickly what that is?
Sure. Physical custody is who has possession or control of the child. Where does that child sleep at night? And then legal custody is the decision, the ability to make decisions on behalf of the child. And those are usually the most important decisions, being educational, religious, and medical decisions.
All right. So if a grandparent gets primary custody, and we talk about that, we're talking about usually physical custody, but we also may be talking about legal custody at that point too. With a lot of these circumstances,
Yes.
if the parents are unable to take care of their child.
Yeah, if you have primary physical custody, you're most likely going to have some form of legal custody as well.
Okay, it could be prime total or could
Shared.
at least or shared with maybe the parents. All right. So that is primary custody. Is there another type of custody involved here?
Sure. There is partial custody or supervised custody as well.
Okay.
And partial custody is when you spend less than the majority of the time with the child. And so mostly grandparents who come to me are saying, I just want to see my grandchild. I just want to spend a weekend with my grandchild. My kids won't let me see the grandchild.
What most people call visitation.
Yes.
But legally we call it partial.
Partial, yes.
Okay.
And so you still, even if you want that visit with your child, you still need to have standing, because raising children is a fundamental right of parents. So if the parents don't want you to spend time with the grandchildren, the courts want to be able to establish that you have standing first.
Okay.
And so once again, you have to show that either the child has lived with you for 12 months and then been removed from your house by the parents, and
you have substantial interest in the child at that point.
yes.
But so a person who gets primary physical custody, you've said, is most likely going to have legal custody, or at least partial legal custody. And but if you have partial physical custody, are you most likely going to have legal custody as well?
Probably not. Maybe you might have a little bit, but if you're having just visitation with your grandchild one weekend a month, the parents are probably still going to have the ability to make decisions. And I do just want to touch upon the two other ways that you can have standing for partial physical custody. The parents of the child have initiated a divorce action, or your child, so the parent of the grandchild is deceased.
Okay, all right. So again, the ability to make decisions that are critical, that Rebecca was talking about with education, health, would only really probably come into play if the parent has primary physical custody.
Most likely.
Okay. Then, so that's custody. Then there's guardianship. And Rebecca, do you want to talk about that a little bit? What is guardianship?
Yeah. So guardian.
And Rebecca, I'm going to interrupt you.
Okay.
If I may. All right. It's actually time for us to take a little break and listen to some good words from our sponsors. We'll be back in a few minutes and continue this vital subject.
For over 50 years now, O'Donnell, Weiss, and Mattei have helped their clients resolve a wide variety of legal challenges. OWM Law provides legal representation to clients throughout southeastern Pennsylvania. The attorneys and highly trained support staff utilize the latest technology and resources available to satisfy the needs of their clients. O'Donnell, Weiss, and Mattei, delivering the highest level of professional service.
Well, welcome back to Legal Talk, brought to you by the law firm of O'Donnell, Weiss, Mattei, PC. Please visit us at our website, owmlaw.com. And today's topic, hopefully you've watched the first side of this program, about grandparents raising grandchildren, a vital topic. We've already heard what are, to me, shocking statistics at how many grandparents are raising grandchildren in Pennsylvania. And with us, Rebecca Hobbs, who's a certified elder law attorney, and that's certainly an area that you get into with grandparents at times. Okay, and Melissa Iacobucci, who concentrates her practice in family law, and so you run into this, Melissa, all the time. And in fact, you have grandparents who come to you with these issues.
Yeah, we were just talking about at the break how
Okay.
I've had that couple of cases recently.
Okay, it's interesting. Well, and I interrupted you, Rebecca,
That's okay.
so it was time for a break, and that is for guardianships. We talked about a little bit of custody.
Right.
Talked about some of the emergency ways that you get into these issues and making decisions, custody, and then there's guardianship. Could you
Right.
tell us a little
Yeah.
about that?
So I think kind of the way that I distinguish guardianship from custody and why we would be looking at a guardianship is where you have more of an absence of someone to raise the child. So where the grandparent has to step in because maybe the parent has passed away or for some reason is absent and not able to care for the child, then that guardianship is what we're looking for. So what is guardianship? So when we talk about guardianship, there's two different big classes of guardianship, and we're not talking about guardianship when it deals with an adult incapacitated person. That's a whole different type of guardianship. So the guardianship that we're discussing today is the guardianship of a minor. And there's two types of guardianships of a minor as well. So there's a guardian of the person and a guardian of the estate. So when we talk about a guardianship of a minor for an estate, that is specifically focused on if that child has assets in their name. So maybe they're inheriting money from someone or some source, and for example, in the situation where a parent has passed away and we are petitioning for guardianship, maybe that parent didn't have estate planning documents done to handle the distribution to the minor, and we're going to court to figure out a way for that child under the age of 18 to inherit that money. And that's going to be the guardianship of the estate. So guardianship of the estate deals with the finances, the money for the minor.
And Rebecca, I've run into this at times, not just when both parents have died, but also grandparents will
Right.
to the grandchildren directly, and they don't set up provisions in their wills as to who should be the guardian, or also life insurance.
Right.
Insurance companies will not pay out any large sum of money to a minor.
Correct.
So that comes up with aunts, uncles, grandparents,
Yeah.
things like that.
Yeah, that definitely comes up. So that's the guardianship of the estate. And then the guardian of the person is really the person that is caring for the child. So that would be somebody that's going to make decisions regarding education and health, and where the child is living. So that's the guardian of the person. So when you think of a guardian, a parent, a biological parent, is the natural guardian of that child. So what we're talking about when we're petitioning for guardianship is where, like I said, there's an absence of that natural guardian, or maybe the natural guardian isn't able to care for the child. And then we're filing a petition for guardianship. And one of the unique aspects of guardianship is depending on the child's age. So if the child is over the age of 14, the court, and when we're talking about guardianship, it's the Orphans Court Division, the petitioner for that guardianship is actually going to be the 14-year-old or above. where if the child is 14 and under, then the petitioner is most likely going to be that person that wants to be the guardian. So the court will look to the parent if the parent is still living, and the court wants that parent to consent to the guardianship. If the parent does not consent to the guardianship, then the court will look for why aren't they consenting? Are they, sick in a hospital and not able to consent? Are they deceased? Are they absent and we can't find where they are? So the court will want to know why the parent is not consenting to the guardianship before appointing a guardian. So when we talk about guardianship, again, usually we're looking at where there's an absence. So there's a death of a parent, or the parent is ill or incarcerated, missing, or potentially a serious drug or alcohol issue that prevents them from being there for their child.
And actually, you normally you'd say, well, why don't you just have that parent sign over temporary rights, as we talked about earlier, but sometimes that's really not possible, is it?
Right. And honestly, I feel like in that situation where the parent is recognizing that for right now they can't be the caregiver for the child.
Like incarceration.
Right. The guardianship really, in my opinion, is the best option because it's going to allow that grandparent to be able to have the authority to make the decisions they need to make. The medical decisions, the decisions regarding education, but it's in no way stripping the parent of their rights, of their natural rights when it comes to the child.
And the other thing it would be for the child that, in fact, if you give temporary rights, then that parent can maybe somewhat whimsically say, no, I decided I don't like mom or dad anymore, and grandparents could be stripped of their rights just as quickly as they got them. Mm-hmm. And only through guardianship can you actually make sure that they'll be able to keep those rights.
Right. And one important aspect of the guardianship as well is the court is really looking to the parent and, looking for the consent of the parent, or the parent can nominate a guardian as well. So, the parent, even in their, when we talked a little bit about a parent passing away, where they have a last will and testament, and they, put their nomination of who they want that guardian to be, the court's going to honor that unless there's a very strong showing of why that person can't be the guardian. For example, if the guardian that's nominated, has an issue with drugs or alcohol or is incarcerated. But otherwise, that nomination in the will is really important in that situation.
And that's also important because you'd say, well, a grandparent would be a good person. We're talking about grandparents with grandchildren here, but many times it's an aunt or uncle.
Mm-hmm. Mm-hmm. Right.
And who could be in the same position as the grandparent. So we could be
right.
having that conversation too.
Yeah, right.
Okay.
Yeah, and I think, when we talk about the ways that a parent can nominate a guardian, there are other ways other than just through the last will and testament. So Pennsylvania does have, they call it a Standby Guardianship Act in our law, and that's an important form that a parent may choose to complete as well, where it is the parent nominating somebody to step in if they're not available. So I know my husband and I have completed one, that in the event that something would happen to us where we're in a car accident or something would happen, we can't care for the children, then we've nominated a guardian that can step in and present that nomination to the court and have that conformed so that they know that they can step in and act as a guardian for our children.
And again, something that most people do not think about.
Right.
And don't do, but something that pops up too frequently.
Right.
And the alternative, if you don't do that, is then you have to go to court without direction. Mm-hmm. Could be competing grandparents even.
Yeah.
Going to court, fight over a guardianship.
Right.
Okay.
Right.
So we have two things we talked about in terms of custody, guardianship. Why would a person look for custody versus guardianship, or vice versa?
I think, first of all, custody, only a certain number of people can file for it. Like I said, you have to have standing. And also, it's more contested. People aren't on the same page. There are disagreement as to who should have custody. Versus the guardianship, it seems as though, and Becky, correct me if I'm wrong, people are agreeing about it, and they say, I want grandparent to be the guardian, and I'm going to consent to it. In custody, there's no consent.
Right.
There's maybe an agreed to order, but it's not something you're consenting to.
Yeah.
Yeah, and guardianship can certainly be contested, but where it might be contested is where you have, for example, two parents that are deceased, maybe something tragic happens, both parents pass away, and there's an absence of someone to care for the child, and maybe no one that has standing to be able to petition for custody. And then, in that situation, maybe you have, like we talked about, two competing aunts or two competing, family members that want to care for the child, and no nomination from the parent as to who they would, want to step in to care for their child. But I think it's important to mention, too, that whether we're talking about custody or we're talking about guardianship, the court is always going to look to what is the best interest of the child. So regardless of if, we're talking about in the orphans court or family court, that's the standard they're always looking at.
That's a good point, Becky, because just because you have standing does not necessarily mean you're going to be granted custody. You still have to overcome that hurdle next, which is whether pursuing custody or having custody is in the child's best interest.
Yeah, and it's interesting. I would say to both of you, the contests involving custody are extremely expensive, are they not?
They are.
Okay, and likewise, a contested guardianship is also of the same nature and also very expensive. So one of the things, and I know it's self-serving as an attorney for all of us, but one of the things that a parent should do is, Rebecca, what you said earlier, you did with you and your husband and children, you have it set up as standby guardianship.
Right.
And the discussion earlier from both of you about having a power of attorney possibly, or some other authorization to the grandparents or aunts or uncles, whomever, having that set up and done properly through an attorney, most likely, all that makes some sense.
Right. It really does. I mean, planning ahead is key. And you have these tools, that we can look to for if something would come up on an emergency basis, we can plan. But also with that last will and testament, it's really important that if you have a child, to have a will, to nominate a guardian, that if you're not able to be there for your child, that you appoint somebody that can step in, and be the guardian. And that way it might avoid these contested issues, because the court is going to look to who your nomination was within your last will and testament.
And I'm going to raise another issue, and then I'm not going to discuss it, and I don't think we have time, but that is adoption, which is actually has some real finality to it.
Right.
Certain custody can always change at any moment as circumstances change. Guardianship, maybe not quite so easily to contest it and change it, but also it's something that can be changed by the court. Adoption is not. So.
Right. Yeah, and I think that adoption really involves the termination of parental rights, which is a whole nother issue that we haven't had a chance to really get into.
No, and we're not talking here about taking rights away from parents. We're talking about grandparents or whomever is caring for that child or those children having the ability to do what is needed to be done.
Right.
Okay. Well, thank you again for joining us today. Grandparents taking care of grandchildren, very important topic. Aunts and uncles taking care of nieces and nephews, very important topic. I hope you've learned something. Thank you.